with the implementation of the 3 new codes being on the horizon. Dr. Mani, I would definitely like to pat you on the back with the enactment of these 3 codes. But really, that's not the line which I am going to toe. I'm going to bring forth the harsh realities at the ground level. Ms. Chaya mentioned, either Ms. Chaya or Mr. Chetan Sharma mentioned that the terminology or the nomenclature of the judicial officers stands changed. Yes, that's a very welcome change. The Metropolitan Magistrate is no longer there in the statute. I take it as endeavor of bridging the gap between the metro-centric approach which Delhi has, or metropolitan cities have, and the other rural, urban India. And that is my stream of thought which I wish to proceed to present. It is imperative that we reflect on our journey thus far and chart the course for a more efficient and just criminal legal framework. We must recall the words of Justice Bhagwati way back in the year 1980. And those who have come from the India would definitely agree with me to say as to whether things have changed thus far or not. And I quote what Justice Bhagwati said. Today, unfortunately, in our country, the poor are priced out of the judicial system, and the result that they are losing faith in the capacity of our legal system to bring about changes in their life conditions and to deliver justice to them. The poor in their contact with the legal system have always been on the wrong side of the line. They have always come across law for the poor rather than law of the poor. That faith would these people have in our justice system of justice administration system is what the query was posed by His Lordship in the year 1980. Have we really progressed since then? Well, in some ways you can say that bringing in with these 3 new statutes, you have taken a big step, undoubtedly. But what does the National Judicial Data Grid tell us? That there are 3 lakh pending criminal cases in different courts of India. And therefore, today I stand here before you, not only as a judge of the Supreme Court of India, but also as a concerned citizen, deeply committed to addressing this pressing issue of pendency in different courts. The cornerstone of any effective justice delivery lies in its ability to deliver timely justice to all. Well, this is the mandate of the Constitution, as has been held in Husainara Khatun. The concept of speedy trial is read into Article 21 as an essential part of the fundamental right to life and liberty granted and preserved under our Constitution. The learned ASG Bihar is here. Khatun came from Bihar. I come from Bihar, and I'm not sure how much have changed at the ground reality. I'm sure in the hinterland, the position is no better, so to say. But nonetheless, there is hope, and the hope stems out from these three new legislations. The inadequacy of financial or administrative capabilities is not a ground to deny the right to speedy trial. Mr. Mani, this is something which you must take note of. Because at the ground level, do we really have the infrastructure to implement the new laws of which we have been speaking since morning? Some introspection definitely needs to be carried out. Adding further, let us delve into the heart of the matter by examining the data relating to pendency, detailed-wise. Delay is one of the most potent roadblocks in the realization of this right. That statement, I'm sure no one can dispute. In the Supreme Court, there are at least 17,000 criminal cases which are pending for more than 3 years. Across India, there are at least 2.5 times more number of cases than civil cases before the Sessions Court. And another alarming statistic, as pointed out by the Law Commission in its 239th report, is that in some states, disposal of criminal cases is lower than the institution of new cases, which results in the burden of the judiciary as an institution being increased year by year, and more so now with the digital platform which we have, an online platform which we have. An expedition into the NJDG data unearthed the following reasons, amongst others, for delay in criminal trials. 1, difficulty in securing presence of important witnesses. 2, one or more accused absconding and not appearing. 3, and this goes to my colleagues across the bar, at the bar, non-availability of counsels. 50 lakh cases are pending only because of non-availability of lawyers. And more than 1.5 crore cases are pending for delay reasons. It quotes delay reasons. What these reasons are, really, one doesn't really know. I'm sure, starting with this note of pessimistic note, I would say, the new statutes would bring in an era whereby at least the poor man, the man who cannot afford litigation, who is helpless, is rendered justice expeditiously. Certainly, it cannot be the case that these statutes are an old wine in a new bottle, but they represent the structural changes and reforms to be in sync with time, also accounting for future requirements of our society. The constructive legislative change has to be accompanied by conscious efforts on either side, that is amongst all the stakeholders, be it an investigator, the prosecutor, the lawyer, or the judge, to continue to tackle the other systematic problems which, while also seeking to translate the written word into a relative reality. The three codes, I must confess, they are tongue twisters. really. Bharatiya Nagrik Suraksha Sanhita, the object and purpose of the Act is to address delay in delivery of justice, large pendency of cases in the courts, low level of uses of technology in legal system, delays in investigation system. The Act provides for the use of technology and forensic sciences in the investigation of crime and furnishing of lodging of information. I need not dilate any further. Much has been said both by Mr. Chetan Sharma and Ms. Chaya, as also my colleague, Madam Palli. The Bharatiya Nyaya Sanhita, for the first time, community service has been added as a punishment for petty offenses. This is in furtherance of the reformative approach of punishment. Offenses of sedition, which he mentioned, and attempt to commit suicide have been deleted, while organized crime has been accounted for. The Bharatiya Saksha Adhiniyam is to keep pace with the advancement of the contemporary world. It addresses the admissibility of digital evidence. The scope of evidence has been broadened to encompass statements conveyed through electronic platforms. And therefore, we now see a whole change of use of technology under this new statute. Definitely, with the passage of time, we'll be able to adapt. We'll be able to first understand and then adapt to the procedures. Now, what is the way forward and the challenges to be tackled? As I have pointed out, statutory changes must be supplemented with adequate infrastructure and administrative capabilities. We must be cognizant of the fact that this is not the first remedial step being taken under these statutes must be supplemented with adequate infrastructure and administrative capabilities. I'm only reminded of one such endeavor by the ministry headed by Mr. Mani as a secretary. The fast track courts endeavor to deal with the criminal cases did not yield any results. It was not really, the government had to discontinue with this fast track courts endeavor. I am sure that you will ensure permanent solution and infrastructure which is permanent in nature. All stakeholders, second is all stakeholders must play their part. On the judicial side, across the bar and bench, private lawyers and prosecutors must work together for fostering a more efficient judicial process. While understanding the difficulties of lawyers in seeking repeated adjournments, balancing the interest of litigant is also necessary. Role of district judiciary in tackling pendency. I was told that a lot of district judges were to attend this conference. I'm not sure they are here or not. But repeatedly, we have been saying so in different capacities as Chief Justice, as judges in the Supreme Court, that the Supreme Court is overburdened with matters which ought to have been dealt with at their level, at the level of either CJM or the district judge, or for that matter, the constitutional courts, the high courts. So that is one, to be specific, is grant of bails and not preventing unnecessary delays therein. I would also highlight one major issue. whenever any statute comes, is there any audit, legal audit carried out? The impact assessment which it is going to have on the existing infrastructure of the judiciary. Illustratively, I'll just, since 1980, we have seen number of statutes which have come. And there is no corresponding increase in the infrastructure at various levels. As Chief Justice, I had to look for judges who could be assigned the duties under the specific statutes, penal statutes. I do remember having faced with a problem where the present Prime Minister was attending a rally and there was a bomb blast. So to deal with this type of statute of national security, I had to look for an officer. I had to look for a person who could handle it. I had to look for a person where he could be placed. And I had to look for a person for the witnesses to be there, the officer who could prosecute. Another issue which I would highlight is that every department, every state has got a litigation policy. If only that litigation policy is uniformly implemented with an earnest effort, the pendency would definitely be taken care of. We do find SLPs in the Supreme Court where even for a sum of ₹50, the appeals are preferred. We find where accused have been acquitted and appeals are being filed after 800 days to 2,000 days. Yes, 2,000 days. We have also find that some of the accused, there's a split trial. The accused have been convicted, but those who are absconding, well, that's the end of the matter for them. And there's none to prosecute them or pursue the matter any further. These are all issues which I am highlighting because with the use of technology, definitely the ministry, or for that matter, the state governments, or the prosecutors, or the people who are in charge, the stakeholders, can examine this and take it further. We have also seen cases where there are disputes between two private government organizations having an overtone of criminality. I am of the view that all these issues must be resolved at the earliest before bringing them to the court. The other imperative reforms I would highlight are these, that with the digital age, crimes are now becoming revolutionized. With data breaches, AI, and use of deepfakes becoming more common, hence implementation of the criminal justice system must be in tune with the technological advancements for tackling these issues head-on. Punishment theory, reforming punishment and sentencing from a deterrent-based one to reformative is something to look at for the future. Madam Chaya mentioned about capital punishment. I look for times when the legislators would ponder over it and do away with it. That's my personal philosophy. Another lot of people are here. A lot of lawyers are here. I would say that you can do great service in taking up matters pro bono. And the legal services movement or the legal aid movement must be carried forward with greater vigor and at every level. The road to a more efficient and equitable criminal justice system is fraught with challenges, but it is a journey that we must undertake with unwavering resolve. By fostering collaboration among all stakeholders, including the judiciary, bar associations, and government agencies, along with leveraging the power of legislation, we can pave the way for a brighter and more just future for the generations to come. Thank you very much. Jai Hind.